We'll also be at the end of the presentation uploading a copy of our PowerPoint and some sample posters you can use if you choose to prohibit firearms and weapons on your workplace to both Moloch and Goisman and H&I's website. We'll be giving the link to those as well at the end. So welcome to Don't Shoot Yourself in the Foot, Understanding Wisconsin's Concealed Carry Law. My name is Renee Kuss. I'm with H&I and I'm a compliance attorney.
And my name is Jennifer Walther. I'm a shareholder with the law firm of Moloch and Goisman. Good morning, everybody.
Wisconsin's, before we get started, we'll be sharing with you what you need to do with regard to the Personal Protection Act. It was signed this summer into law, and it goes into effect November 1st, 2011. Our goal today is to provide you with some basic information about how this law will impact your organization so that you can better decide what policy best fits your needs. So regardless of what policy that you implement, you still need to understand the rights of individuals who have concealed carry permits so that you don't violate, even if you choose to prohibit or not prohibit, individuals that have concealed carry permits do have some rights, and some rights you're not going to be able to eliminate with employer policies.
And then at the end, we're also going to give you some thoughts or tips or strategies for developing policies if you want to take that route as well.
So weapons, as defined in the law, if you have a concealed carry permit in Wisconsin, you're able to conceal carry a handgun, an electric weapon, which includes both a taser and a stun gun, and a knife other than a switchblade. And for those of you who aren't familiar with the law, switchblades are not legal in Wisconsin. And then a billy club. So again, if you have your employee has a concealed carry permit, they can carry these weapons concealed carry either in their car or on their person. In the past, with regard to the electric weapons, in the past only military, law enforcement, and correctional officers were permitted to carry an electric weapon. Now, however, because of the new personal protection law, individuals who have a concealed carry permit in Wisconsin or an out-of-state licensee can carry an electric weapon. This is a big change in the law. So an individual is allowed to possess an electric weapon both in their own dwelling, place of business, or an individual legally owns their their premises. Even if an individual does not have a concealed carry permit, they're still licensed or they're still able to transport a taser or electric weapon so long as it's in a carrying case. And so permits. In order for an individual to carry a concealed weapon, they now would need a permit under Wisconsin law. Individuals can first apply for a permit beginning November 1st, 2011. So they can't apply now and have it be effective November 1st. They have to start applying to the Department of Justice November 1st. The cost will be regulated, but the approximate cost for getting a concealed carry permit should not exceed $50 per person. Applications that are received between November 1st and December 1st, as by law, should be issued as soon as practicable, but no later than 45 days after receiving a completed application. So from an employer perspective, although the law goes into effect November 1st, you won't see employees carrying concealed weapons for at least a couple days after that because they have to submit their application, have their background check, and get the permit in the mail before they can start concealed carrying. Applications that are received after December have to be issued no later, if they're approved, have to be issued no later than 21 days after the application is received, again, assuming it's complete. So in order to get a permit, again, you have to submit a request to the Department of Justice. They have to provide proof of training. The Department of Justice is issuing guidance as to what the training must include in order to qualify for a concealed carry permit. Those draft rules just recently came out, and the NRA has expressed, you probably saw in some Journal Sentinel articles earlier this week, has expressed some concern that the training requirements are too burdensome, but we'll see how that works out. For example, with the training, if you have hunter safety training, that will qualify as training to allow you to apply for a concealed carry permit. You have to be 21 years or older to apply for a permit, not be prohibited from possessing a firearm for whatever reason in Wisconsin, not be charged with a misdemeanor or felony, and the court has prohibited you from possessing a firearm during the proceedings. You have to be a Wisconsin resident. If you are approved for a permit, your permit will last for 5 years unless it's revoked because you no longer qualify for having a permit. So prohibited places. These are places that the general public will not be able to carry weapons, even if they have a concealed carry permit. And the list is here for you, but basically it's police stations, prisons and jails, secure mental health facilities, courthouses, and there are some exceptions to that with regard to judges. We'll talk in a little bit about the exceptions. And then beyond security checkpoints in an airport.
Employers under this law are able to prohibit employees from carrying concealed weapons while the employees are performing work for the employer, so whether the work is performed on the employer's premises or the employee is performing work off premises. The employer cannot, however, prohibit employees from carrying concealed weapons in their personal vehicles, even if those vehicles are parked on the employer's parking lot, or even if the employee is using their own vehicle on company business. So employers now are in a position of having to decide whether or not they want to allow employees to carry concealed weapons while they're working. And if you don't specifically prohibit it, then that means that employees who have a concealed carry weapons license will have the right to do that on your premises. The law provides that if the employer does not prohibit the carrying of concealed weapons by its employees, the employer will have immunity for any liability arising from that decision. We'll be talking in a little while more specifically about what the scope of that immunity may be, but just for now, keep in mind as an employer that if you don't prohibit it, there will be certain forms of immunity. The workers' comp issue, however, means that if an employee is injured while working for the employer, whether you're prohibiting the weapons or not, there's still going to be some workers' compensation claims there. If the employer decides that they do want to prohibit employees from carrying concealed weapons while working for the employer, at a minimum, I think the employer wants to consider posting posters and developing and enforcing a policy regarding what the scope of the prohibition is. And we'll talk at the end about some more specific policy issues that you may want to consider. You may also want to consider as an employer prohibiting specific weapons or all weapons in designated areas. So if, for example, you're not going to prohibit employees from carrying concealed weapons while working, but you have a specific area in your facility or on your premises that maybe contains some hazardous material, you could prohibit employees from carrying concealed weapons just in that designated area. You can also prohibit specific weapons, whether it be a handgun, whether it be an electric weapon, whether it be a knife or a billy club. You can prohibit specific weapons and allow other specific weapons as well. The other thing as an employer you want to evaluate is what are you going to do if you hire temporary employees, which many of you do. Now, temporary employees are usually considered the employees of the temporary staffing agency that's providing the employees to your workplace. What that means is that the temporary staffing agency has the potential workers' comp liability if those temporary employees are injured in the course of their work. However, temporary employees may have potential claims against an employer where they're placed, and so that's where this immunity issue may come on board. Now, the temporary staffing agency as the employer has the right to tell the employees that it's sending on assignment that the staffing agency prohibits the carrying of concealed weapons, and you also have the right, even if the temporary staffing agency allows the carrying of concealed weapons on assignment, you have the right to tell those employees who are assigned to your premises that they cannot carry the concealed weapons while they're performing work for you. The other issue relates to business owners, which is a separate issue from employers. Business owners also need to decide whether they're going to allow visitors to their business to carry concealed weapons. Like employers, business owners can prohibit the carrying of concealed weapons on their premises. If you're going to do that as a business owner, again, you need to post a poster where you're clearly identifying the prohibition. And then you also need to talk about what your policy is going to be, and we'll talk about that a little bit in the end. The law provides that if the employer, or excuse me, if the business owner does not prohibit the carrying of concealed weapons, the business owner has immunity for any liability arising from that decision. And again, we'll talk about what that specifically means. As a business owner, though, you cannot prohibit the carrying of concealed weapons in your parking facilities if those weapons are left in the vehicle. So your prohibition relates to visitors coming on premises. What you want to keep in mind as a business owner is that this is a separate prohibition from the one relating to you as an employer. So if you're a business owner and you have employees, you need to decide what you want to do about your employees. If you're a business owner who doesn't have employees but has people coming on premises, you need to separately decide what you're going to do about those visitors coming on premises. And you can allow employees to carry concealed weapons and prohibit visitors, or you can allow visitors to carry concealed weapons and prohibit employees from doing that. It's not all or nothing. Another area that I think we all want to be aware of, which this new law has somewhat changed the law, is in school zones and on schools. The prior law, before this law came into effect, basically said that in a school, which is defined as, public, private, parochial, which provides an educational program in grades 1 through 12, in the school zone, which is 1,000 feet of school grounds, guns were prohibited within that area, the carrying of guns. Now, under the new law, the Personal Protection Act, if you have a license to carry a concealed weapon, you can carry the concealed weapon within 1,000 feet of the school. You cannot, however, nobody can carry a concealed weapon actually on the school grounds, which includes the actual building and the premises of the school. There are some exceptions to that, which would allow a school, for example, to have a private security guard who's carrying a gun. So if that's part of the contract with that agency in the school, then that would be allowed. If the school allows hunting on its grounds, then guns would not be prohibited in a circumstance like that. So there are some exceptions, but generally speaking, no guns at all on the school premises, but people who do carry concealed weapons can do so within 1,000 feet of the school.
Special events. Special events are defined as something that's open to the public, does not have a duration of more than 3 weeks, and either has locked designated areas and entrances to and from the event, and then the event is actually closed when the event is not going on. So, like, for example, Summerfest would be a good example of a special event venue where it's open but yet it's locked down during times that the park is not open or there's no facility, nothing going on there. A special event, person who's putting on a special event, they may prohibit weapons. They would have to put posters, again, at the entrances to alert people that are coming on to the special event premises that they can't have weapons. Again, the parking facilities are not able to be regulated by the special event organizer. So, for example, the Brewers Stadium, you'd be able to, while tailgating, have firearms and other weapons concealed in your vehicle, but yet you wouldn't be able to carry them into the stadium if the Brewers Stadium decided to prohibit weapons on their premises. So for tailgating, that sounds like an interesting prospect there. To build on that, taverns, individuals who have a concealed carry permit may carry a concealed weapon in a tavern, but they may not consume alcohol while on the premises. Again, a tavern owner can prohibit carrying concealed weapons, but they should know that by law, individuals can carry concealed weapons unless they specifically prohibit it. And the second note, though, that the first part is the new Personal Protection Act. The second part with the asterisk there explains that individuals under the prior law, which continues now, may not go armed, which is a term used in the law, may not go armed while under the influence. So we'll use an example. If you're bar hopping or your employee is bar hopping and they go to one bar and they drink a bunch of alcohol and they go to their car and they get their firearm and they put it in their pocket and go into a different tavern, they wouldn't be violating the law that says they can carry a concealed weapon in a tavern if they don't continue to consume alcohol. But under the previous state law, which again still remains in effect, they'd be violating that law because now they're intoxicated and they're carrying a concealed weapon. So under that state law, they would have a problem with the law. And so when you talk about intoxication, we don't have a blood alcohol limit that gives us a gauge to how much alcohol you can consume and then carry your firearm. But they use the term that you have to be able to exercise clear judgment and steady hand necessary to handle a firearm. My rule of thumb is if a police officer wants to talk to you about your behavior because you've been drinking and then you're also found to have a firearm on you, you probably exceed the amount of alcohol that you're supposed to consume and then also carry your firearm. If an individual is in possession of a firearm and intoxicated and found guilty, the penalty here is 9 months in jail or a $10,000 fine. So it is pretty steep compared to some of the penalties we're looking at in this area. If you consider the tailgating example that we used in the prior slide, and then you consider taverns and consumption of alcohol and how that's all regulated by the law now. In the tailgating situation, in my experience, most individuals in the tailgating situation are consuming alcohol, and so the question is if they have a concealed weapon in their glove box and they're tailgating and they're intoxicated now to the level that their judgment is impaired, argument is that they would be in violation of the law because now they're in possession of a firearm. They wouldn't be in trouble with the law regarding the special event if the special event decided to prohibit the firearms on the premises, but they would have a problem with the state law that regulates the consuming alcohol and having the gun with them. Then the second example that kind of puts some of the different pieces of law together to show you how complicated this can get for individuals who want to conceal carry. If my husband, for example, had a concealed carry permit and we had been drinking at the tailgating party and he put the gun in the glove box, but now because I'm sober, of course, I'm the one driving home, but I don't have a concealed carry permit. And if we were to get pulled over because I'm speeding, the question would be who is in possession of that firearm. I don't have a permit, so it can't be my firearm because I'm not allowed to have, or not by license, by law, allowed to have the concealed weapon in my vehicle. But yet my husband's in no shape to be considered claiming possession of the firearm either. So keep in mind that individuals who are concealed carrying, they're going to need to keep some of these things in mind so they don't end up inadvertently violating the law.
And so with respect to this issue with the taverns, we've all gotten used to now having the designated driver, the one who's not going to be drinking alcohol while going to the bar. Now we have to get used to the concept of the designated carrier, the person who's not going to be drinking on the premises while carrying a concealed weapon.
Some exceptions. We've mentioned it, but we just want to kind of re-itemize it here for you. Parking facilities, business owners, employers, special event organizers, they can regulate concealed carry of weapons on their premises. The parking facilities cannot be regulated. And the common sense reason would be is if I'm driving to work and I choose to conceal carry, my employer can't violate or violate that right by not allowing me to park my car in the H&I parking lot because my gun is in the glove box. Judges can conceal carry, even in the courthouses. That's another exception. And district attorneys or assistant district attorneys, again, can conceal carry. Again, if they have a permit, they can bear arms in courthouses and other areas which to the general public would be not permitted for them.
All right, let's talk about the immunity issues because I think this really gets to the heart of the matter in terms of what people might be concerned about. As I mentioned, if you're an employer who does not prohibit the carrying of concealed weapons, the law provides that you have immunity arising from that decision. If you're a business owner and you do not prohibit visitors from carrying concealed weapons on your business or on your premises, the statute also says you have immunity for liability arising from that decision. Now, the immunity is not described in any more detail under the statute, and so I think that there is a lot of testing that needs to happen with respect to that immunity. But here's, I think, what we know so far. Under the Workers' Comp Act, if an employee is injured in the scope of his employment, the employee is going to have a workers' comp claim whether you prohibit the concealed carry or not. So that legal issue has not changed whether you prohibit it or not. Under OSHA, OSHA is a federal law. The Wisconsin state law cannot overrule a federal law. OSHA has determined that violence in the workplace may in fact be a safety hazard. So under OSHA, all employers have an obligation to provide a safe workplace. And OSHA says that where there's a risk of violence and serious personal injury, if that's significant enough to be a recognized hazard, then the general duty to provide a safe workplace may in fact be violated and may require the employer to take some steps to minimize those risks. So irrespective of whether you prohibit or do not prohibit the carrying of concealed weapons, you still have some potential OSHA issues with respect to any type of injury that may occur on your workplace. If a person has claim for negligence because a third party was injured, let's say you have a visitor to your premises and somebody who's got a concealed carry license comes onto your premises and injures that third party, that's not an employee, so there's no workers' comp claim. Does that third party have the right to sue you, the business owner, or you, the employer, for that injury arising from some potential negligence? If you allow the concealed carry, that's where the immunity kicks in. If you don't allow the concealed carry, it doesn't mean that you have any increased liability than you otherwise would have before the law. What it means is that now we have to go back to what the standard was before the law, which is a basic negligence standard. Did you exercise reasonable care? Was this injury reasonably foreseeable? And so there may be some circumstances, let's say you're a bank in a neighborhood that regularly gets held up. It may be more foreseeable that there's the potential for some gun violence than not. But your immunity has not changed under the law in the sense of what the original liability was. If we have a claim by a third party who's injured by somebody who does not have a concealed carry license, you do not have immunity for that. So that hasn't changed. You only have immunity for the injuries that are caused by the people who have the license. So it very well may be that somebody who's coming onto your premises is going to cause an injury who doesn't have a license. And so that hasn't changed. That, again, gets back to the negligence standard. Did you exercise reasonable care? Was it reasonably foreseeable? Let's say we have an injury that's caused by an employee who does have a concealed carry license. The employee hurts either another employee or hurts a visitor to your premises. The theory with respect to the employer is what we call, in the law, it's called respondeat superior, and what that means is the employer is responsible for the acts of its employee. If you allow the concealed carry on your premises or by your employees, that's where the immunity kicks in. There's no respondeat superior liability. If you prohibit the concealed carry, you don't have increased liability. You have the same liability after the act as you would have had before the act. And that liability is dependent upon whether the employee was acting within the scope of his employment. And usually as an employer, you're going to argue that the employee was not acting within the scope of his employment because we don't allow employees to bring weapons onto the premises. And in fact, this is where we'll talk in more detail about the policy, but if you have a policy prohibiting violence on the premises, he was in violation of a known policy. So you have very minimal liability risk, I think, in those circumstances. If the injury is caused by an employee who does not have a concealed carry license, your liability is the same both before the act and after the act because, again, the immunity only applies if the employee has the license. So then, again, the issue will be, was the employee acting within the scope of his employment? The employees we talked about, if they get injured, their exclusive remedy against the employer is the workers' comp act, so we should not have any concern about any additional liability for injuries to employees. We have to question whether the employer will have liability for a legal theory we call negligent supervision, hiring, or retention. That legal theory is based upon the idea that the employer should have known that somebody had a propensity to harm other people and that it might have been likely to happen in this case. The immunity, if you allow the concealed carry, the immunity in this case may be questionable, and the reason why is the statute specifically says that the immunity is for injuries arising from the decision not to prohibit the employee from carrying the concealed weapon. And so I think that leaves the door open to creative litigants to argue that in the case of negligent supervision, the injury was not caused by your decision not to prohibit it, but it was caused by your failure to properly supervise or to properly hire this person. The liability for negligent supervision claims is the standard is that the employer knew or should have known of the employee's violent propensities. If you know that a specific employee has violent propensities, even though you've allowed concealed carry, you might have an obligation with respect to that specific employee to do something different. So I think in that case, immunity may be questionable, but again, it's not tested. Certainly if I'm defending you, I'm going to argue that you have immunity. Then you also have to look at, in addition to legal claims, there's just some sort of general business issues that you want to consider. If there's, if you suffer a loss of business or an interruption of your business as a result of some incident, there's no recourse for recovery under the law. That's, Renee is going to talk in a minute about insurance issues. You also have to look at your public image in terms of what are your customers going to expect you to do, what are they going to want you to do, are they going to feel comfortable coming onto your premises with the thought that there may be people carrying concealed weapons or there may be employees carrying concealed weapons, or are they going to feel more comfortable with that, the theory being that people may be less likely to engage in some sort of gun violence because they don't know who on the other side is going to have a gun. You also have special issues related to, for example, if you're in a business caring for a vulnerable population like nursing homes. Nursing homes have residents who are vulnerable and who are businesses to protect, and so we may want to decide that we don't want our nursing home residents to carry concealed weapons because we might think that that's a risk. So we do have the right to prohibit that in that instance. So Renee is going to talk about the insurance issues related to these issues.
Real quick, from the customer standpoint, if you might be wondering, how will your customers know whether or not your employees are carrying concealed weapons? For individuals who are more sensitive to this issue, they'll know that they'll see as this starts to get implemented, you have to put a poster at all the entrances in your organization. So if they are seeing those posters when they go to some places like Target or the grocery store, and then they come to your premises and they don't see those posters, for those individuals who may be more, interested in whether or not people are carrying weapons because of how they feel about guns, that they will know what your policies are, whether or not you tell them because you've got these posters or you don't have these posters around. From an insurance standpoint, as Jennifer mentioned, as an employer, when individuals are doing things that are work-related and they have work-related injuries, again, workers' compensation is going to cover you as they have in the past. In a different situation with, for example, if you have an employee who has an ex-boyfriend that comes on the premises with a firearm because they're not getting along or they've just gotten separated, that wouldn't be necessarily or arguably not a workers' comp injury if the ex-girlfriend were injured by a firearm or a weapon on the premises because it's not related to the work-related work that they're doing for you. Your general liability policy will not cover intentional acts. So you're not a lot of coverage in your business policies for this kind of injury except liability except for your workers' comp. What you might want to consider, and there's no certain answer in some of these areas, but what you might want to consider as an employer is employment practices liability insurance, which we also call EPLI. That kind of insurance protects you against claims that are brought against you for discrimination and unfair hiring practices. It may, depending upon the policy, protect you against those claims that Jennifer was talking about, the negligent supervision in hiring. For example, if you allow firearms in the premises and you have a person who's constantly threatening somebody and you didn't take it seriously, you didn't act upon it, it's possible that some EPLI coverages may help to offset some of your expenses if you are, in fact, to have a loss there. From a business owner standpoint, again, the general liability policy is not going to cover intentional acts, which generally is what's going to happen. The accidental discharging a weapon may be covered under your policy, but definitely intentional acts will not be covered. From an individual perspective, individuals who have permits to conceal carry, there is some limited liability there, some limited ability to get insurance there, and the reason why, as a business owner, an employer, you should care is because these individuals may be, for example, concealed carrying a gun in their car, in your parking lot, and also using their vehicle for personal business, and you can't prohibit that. So on a positive note, those individuals, their umbrella coverage may protect them against an accidental discharge of the firearm in their vehicle because the umbrella policy follows their vehicle. There is the NRA, through an insurance agency, is selling what they call self-defense insurance. You just go on the internet and enter your information. It's like PayPal. You enter your charge card and you're issued a policy for about $304 a year, and that coverage, the maximum coverage limit is $250,000 per incident, and it's covering claims that are related to unintentional acts. So what they'll do is, if you're found innocent that you didn't intentionally shoot someone, they'll reimburse you for your legal fees. So there is some limited coverage. So again, it's under either the umbrella policy or under these special self-defense policies that are related to people who are handling guns on a regular basis. I think that kind of covers it. So again, kind of consider your insurance coverage, knowing that in most cases it's not going to be covered. And that also, with regard to the individual coverage, some organizations that have employees using their personal vehicles for business reasons will require, as a term of employment, a condition of employment, that they carry certain basic limits of auto liability coverage, and they're required to provide evidence of coverage on an annual basis. You might want to consider doing that if you're an employer that has individuals using personal vehicles for business reasons, because of the firearm issue as well. Kind of adds a layer of exposure there. And then you may consider, as part of your terms of employment, having a minimum umbrella limit, because again, if someone is on company business using a personal vehicle with a firearm and something happens, the employer is going to be the deep pockets. But if you have your employee, you require them to have some basic coverage limits, there's a chance that you'll be able to deflect some of those costs onto them if they're somewhat liable for what happened.
Now, as you business owners and employers are deciding whether you want to allow or prohibit the carrying of concealed weapons by your employees or on your business premises, I think there's a couple of important things for you to keep in mind, that the law has not changed. So, for example, the law has not changed what the pre-existing law was on the right to exercise self-defense. Generally, the standard is that any force that you use in self-defense has to be proportional to what the force is that you're trying to counteract. So if you see somebody is about to attack you or about to attack a third person, you do have the right to use self-defense, but you cannot intentionally cause death or great bodily harm unless you believe it's reasonably necessary to prevent death or great bodily harm to yourself or to that third person. And so what that means is that just because people with licenses may be carrying concealed weapons does not give them the right to pull them out and just shoot somebody. It really is only to be used in a self-defense situation where they reasonably believe they need to do so to prevent imminent death or great bodily harm. Another issue is that a lot of the local laws have not changed. So, for example, there are many city, village, or town ordinances that restrict the discharge of a firearm within the limits of that municipality. So there will be an exception if it was a legitimate self-defense situation, but it does mean it's not like the Wild West where these people carrying concealed weapons have the right to run around town just shooting them off at will. State law prohibits discharging a firearm near some parks, from a vehicle, from or across a highway, into a building, or, and this one seems a little bit more difficult to me, but from an aircraft. So those prohibitions are all still in place. So those are things we shouldn't have to worry about. A person cannot load or carry or go armed with a firearm with a malicious or illegal intent. That may be a little bit difficult to prove, but nonetheless, if my intent in carrying my concealed weapon is to go over to my neighbor's house to shoot him, that's an illegal intent, and then I'm not allowed to do that, even under this concealed carry law. I cannot, even if I have a concealed carry license, intentionally point a firearm with malicious or illegal intent. That means I can't play Russian roulette with you. And then I also cannot negligently or recklessly endanger the safety of another with a weapon. So again, I just can't recklessly discharge it and, you know, frighten you out of your wits. So the whole point of the concealed carry is meant to be for people to exercise self-defense. It's not an opportunity for them to go around and scare people with their guns or to use it willy-nilly. So we want to talk now about, as we come to the conclusion, what are your next steps? What are you going to do now that we're faced with this law? Because I do think that you have to make a decision. You have to decide if your organization will allow firearms on your premises. You have to decide if you will allow employees to carry concealed weapons while they're performing work for you. And if you simply do nothing, that means you will in effect be allowing it because they have the right to do it. If you decide you want to prohibit it, you need to take some proactive steps by displaying the posters, which Renee will talk about in just a minute. What I want to talk with you about is some policy issues that you may want to consider, because I think a policy will be very important. If you decide that you will not prohibit the carrying of concealed weapons by your employees, you may want to consider requiring employees to disclose to you that they will be carrying a concealed weapon on the premises, because then at least you have an idea of what the scope of it will be. How many weapons are you going to have on premises? I think you should definitely consider requiring employees to show you their license to carry the concealed weapon if in fact they're going to carry it, because the law only allows them to carry it if they have a license. And so if an employee comes on to work with a concealed weapon and doesn't have a license, then you have the right to prohibit that. And again, keep in mind the license is only issued by the Department of Justice after going through an application process which requires a background check, which is designed to determine whether somebody's prohibited from carrying a weapon at all. And it also requires proof of training. So there are some standards, so presumably people will have some ability to use the weapon that they're carrying. You want to determine in your policy whether all weapons will be allowed or only certain weapons. Do we want to allow handguns but prohibit electric weapons, for example? So you should specify in your policy what weapons you're specifically allowing or what weapons you're specifically prohibiting. You want to determine whether there are areas on your premises where all weapons or certain weapons may not be allowed. So we talked about that earlier. For example, if you have an area where there's some hazardous chemicals, some hazardous waste, something that might a spark might easily inflame and cause substantial damage, you can prohibit the carrying of weapons in that specific area. You want to have a procedure available for employees to raise concerns if they feel unsafe. Again, you know, OSHA has decided that it may be a safety violation if there's the serious risk of violence. And so I think part of providing a safe workplace is not only having the policy, but having a procedure for employees to raise concerns. You want to identify a specific person that they can go to if they feel unsafe. If an employee comes to whoever that designated person is, you want to investigate that employee's concerns and take action if necessary, because that's going to be part of your obligation to provide a safe workplace. And I think that's true before the law, after the law, that hasn't changed. You can prohibit visitors from carrying concealed weapons even if you allow employees to carry. So, again, keep that in mind. You can decide to do that. You probably also want to consider prohibit the carrying while intoxicated. Now, that's required under the law anyway, but as a matter of policy, you don't want to allow employees to carry while intoxicated. You certainly don't want them to carry while under the influence of illegal drugs. Now, you probably already have provisions like that in your employee handbook that prohibits employees from showing up to work under the influence, but I think you want to have a separate provision related to the carrying of weapons, because that could be an even more serious offense in your eyes. You also may want to consider prohibiting the carrying of concealed weapons if employees are under the influence of even prescription medication or over-the-counter medication if it's going to impair their judgment. So those should be policy issues that you want to consider in your policy. If you are going to prohibit the carrying of a concealed weapon, you definitely should have a written policy. You should make sure you distribute that policy to employees, and employees should acknowledge that they've received and understand the policy. The policy should be consistently and reasonably enforced. So if you have a policy that you're prohibiting the employees from carrying concealed weapons in the workplace, and you know that, Bill Jones is carrying a weapon and you don't enforce the policy, now you're not going to be protected. That's going to be a negligent situation, and you're not going to have the immunity because you prohibited it. So, so you have to be careful about the enforcement. You want to, again, specify what weapons are prohibited. You cannot prohibit weapons in the vehicle, but the statute does not prohibit you from requiring the vehicle to be locked. So you may want to consider doing that. You may want to consider requiring a handgun to be in the glove box or in a locked trunk. You can prohibit weapons from being carried outside the vehicle on the parking lot. So you want to address that in your policy as well. And finally, you should explain the disciplinary consequences of violating the policy. You probably want to say something like, will result in discipline up to and including termination. Whether you decide to prohibit concealed weapons or not, there certainly are steps that you should consider taking to minimize the impact of what may or may not be any increased violence, but certainly to the extent that you may be concerned about the perception of it. You want to have a zero-tolerance policy for violence. And so what that means is even if you're going to allow employees to carry concealed weapons on premises, it still means that they're not allowed as a matter of policy to engage in violent acts, solely to be used for self-defense. You want to train supervisors and managers to recognize and report any kind of troubling conduct. You want to require employees to report any threats or any abusive behavior so that you can take some action. You want to investigate all acts or threats of violence. You want to have an action plan for responding to an incident of workplace violence. You want to take proactive steps in the hiring process. You may want to consider background checks, and particularly if you're going to allow the carrying of concealed weapons. Now, presumably to get the license, they're doing a background check, but you may want to get the information independently. You want to check references. You want to look at the job history. You want to find out, why did that employee leave the last job? Was it for some violent-related incident? So you're going to want to know that. If you're terminating somebody, you want to take some proactive steps to protect you and your workforce. The reasons really should not be a surprise to the employee, but sometimes they are. So you want to call the employee into an appropriate separate location to discuss the termination, whether it be in an office, a private office, or somewhere that's away from other employees. You want it probably to be near an exit so you can escort the employee out as quickly as possible without having to walk through a gauntlet of other employees or onlookers. You want to choose a time for the termination where there's a small chance of other people being present, so at the end of the day or the beginning of the day. Some people now say the theory is to terminate people on a Monday instead of a Friday, so that on a Monday they have the rest of the week to get going on looking for a new job, whereas on a Friday they just sit around and stew about it all weekend long and get mad. You want to make arrangements to send for the employee's personal belongings from their workstation and bring it back to wherever that termination meeting is being held. Don't let the employee go back to the desk alone or back to their office alone. And I've seen cases, what happens is they call the employee into the room, tell him he's terminated. He says, I need to go get my stuff. He goes back to his desk, comes back with a gun, and shoots people. There are cases like that where that happens. So you want to prevent that from happening. And you want to assess your security measures. You want to be able to look at, what's the lighting like? Do we require people to sign in when they come in? Do we require employees to wear badges? You don't have to do any of those, but whatever you feel is appropriate for your business is something that you want to assess. And then finally, if you're aware of a domestic violence situation, you may want to consider some steps like giving an employee some time off or helping that employee to obtain a restraining order. And I did have a client who did have a situation was very, very threatening, where it was the former husband of an employee who was stalking and harassing other employees. And so, managing those situations really will help to minimize any potential risk.
I think even with the personal issues that may be bringing violence to the workplace, encourage employees to tell you about it in a confidential manner so that you can deal with it and address it versus having them keep it to themselves and then be faced with a surprise violent situation at work. Going back to one of the things that Jennifer also mentioned with regard to policies, we talked about maybe sometimes there's a reason why you might have different rules regarding firearms and weapons in different locations. You may consider whether or not you're going to allow firearms and weapons on the premises, but with regard to your company-owned vehicles, you may choose to ask or require your employees not carry concealed weapons in your company vehicles because they're going out to job sites, a little bit more risk there because they're more mobile versus being in your office where there's less chance that a customer would get hurt. Also point out that, regardless if you allow guns or not, you should be communicating to your employees what your position is on this situation so that they know if you're not going to prohibit guns and they happen to know that so-and-so has a gun at work, you need to kind of control so they don't overreact or come and report to you or get kind of excited about it. So I think regardless of what you decide, you should be sharing that with your employees. I think all employers, regardless of what they're going to be doing with regard to prohibiting firearms and weapons on their premises, should review their policies. We have, for example, some employers that we've seen their policies and it prohibits guns. And they think, well, I'm not going to do anything about this new law, but now their policy has taken a stance on it for them and affects their immunity. And when it says we won't prohibit guns in the workplace, it doesn't address the fact that weapons are now allowed to be concealed carry. So what is your position on tasers, firearms, trying to think of other, the billy clubs and the knives. So your policy is now not broad enough to really tell employees what's expected of them. And then, let's see, one more thing. I have a question for Jennifer before I open it to questions for you. We talked about providing a safe workplace, and if you have an employee who is consistently acting violent or making threats to people, even if you allow weapons and guns on a workplace, I'm wondering if part of the disciplinary process could be, Bob, you seem to have a problem with your management, and although we allow guns in the premises, what do you think about just telling Bob he can't conceal carry? Because now he told you he had a permit, and he's been acting strangely. His permit may not have been revoked yet because the authorities are not aware of his behavior, but you are. So what do you think about just going to that one employee and saying as part of your process, you're not bringing your gun to work anymore?
I think we have the right to do that, although I know Bob's lawyer is going to say I'm violating his rights and I'm singling him out. But right now, although he has a right to do it under the law, I think my right as a business owner to prohibit violence on the premises will trump that right, and my obligation to avoid any kind of liability to my customers or my employees. Now, Bob's right is not what we call a protected class, so he can't claim that I'm discriminating against him. by treating him differently than other employees, because although I am treating him differently than other employees, I'm not doing it based on a protected class like your typical race or sex protected classes. So I don't think you're going to have a discrimination claim there. And I think that really will get to the heart of the matter. I think if you have a specific employee that you have some real concerns about, I do think you have a right to treat them differently.
Right. Because we talked about immunity is when you allow firearms and weapons on the premises, but yet we talk about this requirement to provide a safe work environment,
Yeah.
which could undermine your immunity.
Yeah.
And now you do have a situation that your immunity might not be helping you very much if you don't act appropriately.
Exactly. That's exactly right.